Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 142. As usual, we've got three cases, of course, but they're all three Court of Appeal decisions, which I think is something of a rarity. First off, we've got the Osipov case, which I think effectively rewrites whistleblowing claims. Secondly, we've got the latest instalment in the Morrison's case and the impact on Morrison's of the deliberate disclosure of personal data held by it, and the disclosure was by a disgruntled employee, soon to be ex-employee. And thirdly, we've got a case on tribunal jurisdiction and contracts of employment. Please don't forget, as usual, you can access our podcast via iTunes, Mayor Brown website, YouTube and Twitter feed as well. And that's where the links to the cases go out, and that's Nicholas Robertson at Nicholas ROBER11. Could I also give a plug to the special guest podcast we did with David Reed QC last week? It's on the subject of privacy in employment tribunals. It's a really hot topic, and we thought it'd be a great idea to have David come in and talk about what is public in employment tribunals and when. Equally, if you've sensitive confidential documents or difficult matters relating to, for example, allegations of sexual misconduct featuring as part of the fact pattern, what can a tribunal keep private and out of the public domain? Do please have a listen to that. Whilst we're on the subject, I'm also going to do a one-off podcast on the subject of non-disclosure agreements. We did talk recently for clients on the future of non-disclosure agreements, and the intention is that'll probably come out next week. So it'll be a short one-off current thinking on non-disclosure agreements. As a reward for all of that, I haven't done a film review for a while, so I'll do a film review at the far end. So, first case, Timmis and Sage and Osipov. This is a case that has been working its way through the system in relation to the personal liability for individuals involved in imposing a detriment on a whistleblower. The background is that Mr. Osipov, who's the claimant, was originally employed by International Petroleum Limited. Two of the directors, Frank Timmis and Anthony Sage. Mr. Timmis is the largest individual shareholder. Mr. Sage was the chairman. In October 2014, Mr. Timmis, with the agreement of Mr. Sage, decided that the claimant should be summarily dismissed. An employment tribunal subsequently found that the reason for this was because he'd made protected disclosures against the company. This meant that he was automatically unfairly dismissed under Section 103A of the Employment Rights Act 1996. However, the company was, by that stage, insolvent. The tribunal's award is now for a little over £2 million in total. The claimant had also included in his tribunal proceedings claims under Section 47B of the Employment Rights Act. This gives a worker, not an employee, a worker the right not to be subjected to any detriment by the employer done on the ground that the worker had made a protected disclosure. And as I say, that applies to workers with a wider category. It's not just limited to employees. And this is the so-called detriment claim as opposed to the dismissal claim under Section 103A, which is limited to employees. Section 47B, however, provides that Section 47 does not apply where the worker is an employee and the detriment in question amounts to a dismissal. There was no dispute that Mr. Osipov was an employee. The question for the Employment Tribunal, then the EAT, and now the Court of Appeal was, could an award be made against the directors of the company personally if they'd taken the decision to dismiss the claimant so that they were going to be liable for damages calculated by the tribunal at nearly £2 million? Although in this case the directors had insurance that covered the claim, the Court of Appeal pointed out, of course, this would not necessarily always be the case, and obviously that was not relevant in deciding whether or not they were liable in this case. The Employment Tribunal accepted the directors could be liable for their actions, and this included the consequences of the dismissal on the basis that the losses flowed from pre-dismissal detriments for which they were liable and which amounted to a detriment. The case before the Court of Appeal was that because Section 47B2 excluded dismissal claims from the detriment provisions, neither Timmis nor Sage could be liable to the claimant, who was an employee, in respect of an instruction to dismiss the claimant. Secondly, under Section 47B2, they were not liable for losses which flowed from the subsequent dismissal. The Court of Appeal decision is, to be honest, quite lengthy and fairly dense. However, it does come down decisively in favour of the claimant. Section 47b(2) states that 40 Section 7b does not apply where the detriment in question amounts to a dismissal. You could see a case where there might be an argument as to whether there had been a detriment done beforehand which led directly to a dismissal. Would Section 47b(2) exclude that prior detriment or not if it was closely linked to the dismissal? Obviously, this would be quite fact-sensitive. In this case, the respondent's argument was that the detriment amounted to a dismissal and therefore was excluded from Section 47b if the losses to be recovered are in essence losses flowing from a dismissal, and or if the act said to be the detriment is in substance nothing more than dismissal. Court of Appeal accepted it's necessary to look at the substance of the alleged detriment. You can't sidestep that by dressing up a dismissal claim as a detriment claim. However, they sided with the claimant and said that what was being excluded under Section 47b(2) was a claim of dismissal against the employer. In other words, the legislation did not prohibit claims for dismissal against anyone other than the employer. The respondents pointed out, if that was correct, it would have two significant impacts. First, there's a line of cases which indicate that for a detriment whistleblowing claim, it's possible to award compensation for injury to feelings. It's not possible to do this on a dismissal claim, because generally, for unfair dismissal, it's not possible to award compensation for injury to feelings, and a whistleblowing dismissal is merely an automatically unfair dismissal. Secondly, there's a less restrictive test of causation for detriment claims as opposed to dismissal claims. Why would a claimant ever take the dismissal route, Section 103A, when Section 47b was easier and gave rise to more compensation, said the respondents. Well, the court, however, pointed out there were anomalies either way. If all dismissals were excluded against all potential respondents and had to be brought under Section 103A, circumstances could arise where co-workers brought about the dismissal of a worker but could not be sued for that dismissal. The employer might well be acting perfectly reasonably and without any liability for whistleblowing itself. The example was given of an individual who was so badly bullied by co-workers for making protected disclosures that ultimately that individual breaks down and the employer then fairly dismisses them. The employer in that example would be dismissing fairly and so wouldn't be liable. If all dismissal claims against individuals were banned, then there would be no one who was liable for the wrong. The Court of Appeal said it would be clearly wrong if the co-workers who'd acted in that way were protected from being sued for bringing about the dismissal. The other point that was made was that it was clear that workers can claim for dismissal damages under Section 47b if they're not employees. This is because Section 47b(2) only excludes cases where the claimant is an employee and the detriment amounts to dismissal. Clearly, a worker cannot bring an unfair dismissal claim, so for a worker who's not an employee, any detriment claim, including dismissal, has to be brought under Section 47b. Section 47b(2) can't exclude it because a worker who's not an employee can never be covered by Section 103a. So, in other words, long way round of saying, Section 47b clearly covers some dismissal cases. It covers all dismissal cases brought by workers. Court also suggested it would still make sense for claimants to use the Section 103 route because it's possible that there are additional remedies available for unfair dismissal, such as reinstatement or re-engagement. In addition, individuals could claim a basic award if there's a dismissal case, but not if it was a detriment case. If you remember, the respondents were arguing as well that they were not liable for the damages flowing from the dismissal. The court said it would be possible for individuals to have compensation awarded against them where their actions led to the employer dismissing the whistleblower. This would be subject to the usual rules on causation and remoteness. But they said that 47b(2) did not preclude the tribunal awarding damages for wrongful acts which lead to dismissal, and for those damages to include losses flowing from the dismissal. So, the upshot is that the two directors are potentially liable for an award of £2 million for whistleblowing damages. I think whichever way you look at this is a hugely significant case. The effect of the Court of Appeal's decision is that claimants will always look to bring Section 47b claims now. It seems that in reality, Section 103a, the dismissal route, is a dead letter, despite what the Court of Appeal say. I think it's quite right to say that there is no obvious, consistent and logical way of interpreting all the legislation. Whichever way you do it, there will be anomalies. But I have to say, personally, it does seem to me very odd for the court to have taken an interpretation that means the provisions laid down under Section 103a have been swept away, and the test for liability for dismissal, which is understandably a tougher test than the mere test for a detriment, well, that's been swept away too. I don't know yet whether the case is being appealed. I think it must be likely that it will be. The duty case, if you remember, that's the case of the IAGO manager procuring the dismissal of a whistleblowing employee. Well, that case is going to the Supreme Court. Maybe this could go alongside it. In the meantime, I think employers are going to have to be resigned to the fact that there will be many more claims against individuals involved in the alleged detrimental activity. And if you're a manager and you're asked to get involved in a dismissal or a grievance involving the whistleblower, you may well want to make sure your employer has promised to indemnify you for any claims that might arise, because you could very easily find yourselves named as a party in litigation to bring the claim within Section 47. So, in short, that's Timmerson, Sage and Osipov, and why a lot more claims of detrimental whistleblowing treatment are going to be brought against managers. So, next up, Morrisons Supermarkets plc and various claimants. This case is the ongoing saga of the consequences of the deliberate data leak by an employee of Morrisons and the potential liability caused for Morrisons as a result. And the case concerns more than 5,000 employees or former employees of Morrisons who are suing Morrisons for that data breach. Background was that a senior IT internal auditor was given a verbal warning by Morrisons back in 2013. He developed a grudge against them as a result. Several months later, and at the request of the external auditor, a USB stick was loaded up with Morrisons' payroll data. The internal auditor, the disgruntled employee, made an unauthorised second copy of the data, which contained the personal details of 99,998 employees of Morrisons. He uploaded this to the web. He then tried to get the press interested in the story. He was arrested, is now partway through an 8-year jail sentence. But the claimant sued Morrisons for damages and interest for misuse of private information, breach of contract, and breach of statutory duty under Section 4.4 of the Data Protection Act, and they claimed that Morrisons was vicariously liable for the wrongdoing of the individual. We dealt with this case back at the High Court stage, where the judge held that Morrisons was not the data controller at the time, and so was not directly liable for breach of confidence or misuse of private information, since it was not Morrisons which disclosed the information or misused it. But the judge did find that Morrisons were vicariously liable for the actions of the hacker. The High Court judge decided that Morrisons were vicariously liable because the Data Protection Act, which sets out various obligations on Morrissey as data controller, did not have the effect of excluding vicarious liability for breaches of statutory duty. Secondly, the Data Protection Directive was intended to amplify the rights of data subjects, and it was always open to a state to augment a minimum EU-wide standard of protection. Therefore, the judge did not accept that the Data Protection Act excluded the common law and equitable actions in respect of data disclosure covered by the data protection legislation. The tort of misuse of private information and the action for breach of confidence were, the judge said, complementary to the Data Protection Act obligations, not contradictory, and so they survived. Having decided that, in principle, Morrisons could be liable for breach of the vicarious liability, the High Court judge, decided there was a sufficient connection between the position in which the internal auditor was employed and his role and conduct, and therefore it was right for Morrisons to be held vicariously liable. Morrisons, unsurprisingly, appeal. Their appeal was on 3 bases. First, that the Data Protection Act excludes vicarious liability. Second, the Data Protection Act excludes the causes of action relied on by the claimants to establish vicarious liability, because an action for misuse of private information and breach of confidence are matters covered by the data protection legislation. Thirdly, it was argued that Morrisons should not be vicariously liable on the facts, because here there wasn't a sufficient connection with the wrongdoer's employment. Court of Appeal rejected Morrisons' 3 grounds for appeal. Morrisons argued that the Data Protection Act did indicate sufficiently clearly that it was intended to exclude vicarious liability. They argued that the legislation was about achieving a balance between the right to privacy and the free flow of personal data, and that given their express obligations, as there are on any data controller, which are expressed to be proportionate obligations or appropriate obligations, an employer who complied with these obligations should not then find it as vicariously liable for the actions of its employee. Moreover, Morrisons argued that the data protection legislation is specialist legislation which is intended by Parliament to cover the entire field of liability of an employer for the wrongful processing of personal data by it of an employee. But, Court of Appeal was having none of it. Their view was that if Parliament intended there to be a substantial eradication of common law and equitable rights, He even said so expressly. Moreover, Court of Appeal pointed out that Morrisons were contending that the data hacker was personally liable for misuse of private information and breach of confidence. In the circumstances, to argue that vicarious liability for those actions was eradicated, but the underlying torts remained, well, that was a difficult road to tread. Ultimately, the Court of Appeal was comfortable that vicarious liability itself was an anomaly and that it imposes liability on an employer who is guilty of no fault. The same applied here. Morrisons also had a go at trying to argue there was not a sufficient connection between the position in which the individual was employed and the wrongful conduct which was sufficient to make it right for the employer to be held liable. Morrisons argued that the tortious act which caused the harm was done by the data hacker at his own home using his own computer on a Sunday, several weeks after he downloaded the data at work onto his personal USB stick. However, the court had decided this argument did not work, and the Court of Appeal agreed. The data hacker had copied the data at work, having researched the office systems as to how best to go about it. He had used the name and birth date of a colleague to try and cover his tracks when posting it online. All his actions were part of a plan connected with work going back to the unlawful copying. It was a seamless and continuous sequence of events. Even the point that his actions were devised to harm Morrisons, and so the court in effect was doing his bidding by finding that Morrisons was vicariously liable, did not deter the Court of Appeal. The Court of Appeal took the view that the data hacker's motive was irrelevant, as it usually is for cases of vicarious liability. So ultimately the Court of Appeal said, in their view, the answer for employers was to insure against such a catastrophe, and the availability of insurance would be a valid answer to the doomsday arguments put forward by Morrisons. I think the case is a very significant one. Employers must be concerned that they can be completely innocent of wrongdoing, but effectively trusted employees can cause them significant problems by deliberate wrongful acts. Of course, I recognise that vicarious liability has been around for a long time. Employers have no option but to live with the risk that comes merely from employing someone. But it's difficult not to feel that Morrisons is the predominant victim here. It is not to blame in any way for what happened, and is looking at a potentially very significant sum in damages. I don't think this is the actual situation on the facts, but if all 100,000 employees claim damages of £1,000, you're looking at £100 million for something you're not responsible for other than because you're the employer. Rather more troubling than even that number, I would be very interested in knowing if anyone's come across any insurance policies that cover this. I think there's at least a question mark about how that would work and whether there are any issues. My insurance team here at Mayer Brown have written an article about some of the complexities of getting insurance in this area. So if anyone is interested, please let me know and I'll send you out a copy of the link. But anyway, I would be very surprised if Morrisons don't seek to take this to the Supreme Court and at some point during 2019 for the Supreme Court to grapple with this. So that's William Morrisons, W.M. Morrisons Supermarkets plc and various claimants, and why employers are supposed to take out insurance to cover the risk of deliberate wrongdoing by their employees. Third up, British Council and Jeffrey. This is one of a pair of joined cases dealing with employment jurisdiction. In particular, it related to the jurisdiction of the Employment Tribunal to determine claims by employees who were working at the relevant time outside Great Britain. The Jeffrey case concerned an individual who lived in Bangladesh, where he worked for the British Council. The Council runs teaching centres, which includes 3 centres in Bangladesh. Operational decisions are taken at regional, country or local level. And the teaching centres have significant financial and commercial autonomy. They're funded entirely from fees raised in Bangladesh, with salaries and expenses being met locally. Mr. Jeffrey had worked in a number of the teaching centres for many years. He did not ordinarily live in the UK or have a home in the UK, although he did have some property in the UK which is let out. His parents still lived in the UK, and he hoped to retire to the UK in due course. Crucially for our purposes, his employment contract was governed by an offer letter, which expressly referred to the contract being governed by the laws of England and Wales. He was paid in sterling, had a membership of the Civil Service Pension Scheme, and he was subject to the Official Secrets Act. The parties fell out. Mr. Jeffrey brings a claim in the UK for unfair dismissal, whistleblowing detriment and religious discrimination. The Council disputed the ability of the Employment Tribunal to hear the case. It contended that Mr. Jeffrey worked exclusively outside Great Britain and therefore the Tribunal did not have the statutory jurisdiction to hear any of these claims. Mr. Jeffrey lost in front of the Employment Tribunal. The judge accepted that Mr. Jeffrey was truly an expatriate worker. Having reviewed the factors, the judge felt that they did not exert any particularly strong pull towards Great Britain. At the end of the day, the tribunal concluded that he was posted aboard by a British employer for the purpose of work carried out in Bangladesh. Such connections as there were, according to the tribunal judge, did not amount to connections with sufficient strength to displace the general rule that expatriate workers were not able to bring claims in Great Britain. The Employment Appeal Tribunal allowed appeal against that, and then the British Council appealed to the Court of Appeal. The Court of Appeal provided a very useful short summary of the main principles for looking at whether someone who worked outside Great Britain could bring a claim in the English or Scottish tribunals. It's a great place to look if you're grappling with this area for the first time. The background, of course, is that originally the Employment Rights Act 1996 and the equivalent provisions dealing with discrimination legislation had specific territorial limitation and statutory tests for when employees were able to bring claims to the Employment Tribunal or not. This was simply repealed without anything being put in its place. The courts have been left to work out the appropriate tests. In general terms, Parliament could be taken to have intended, the court said, that an expatriate worker will be subject to employment law of the country in which he or she works, rather than the laws of Great Britain. But there are exceptional cases where there are factors connecting the employment to Great Britain, and British employment law will pull sufficiently strongly in the opposite direction, so as to grant the Employment Tribunal on the basis that Parliament must have intended someone in that situation to have British employment rights. In each case, one is required to compare and evaluate the strength of the competing connections with the place of work on the one hand and with Great Britain on the other. And this applies both to claims under the Employment Rights Act and to claims under the Equality Act 2010. Here, there were a number of issues raised on this appeal, but I just want to focus on one. In looking at whether an individual had a sufficient connection to Great Britain, it is relevant that the contract of employment governing the relevant job has a provision that says it will be governed by English law. The Council's position was that there was an express choice of English law, but English law is in principle irrelevant to deciding whether or not there was a sufficiently strong connection to grant a tribunal jurisdiction. In other words, differentiating choice of law clauses from choice of jurisdiction clauses. First of all, they said that saying a contract will be governed by a particular country's laws is very different from saying that a particular country's courts will have jurisdiction to determine the claim. Additionally, a choice of law in a contract would only be relevant to interpreting contractual rights, whereas Mr. Jeffrey was trying to enforce statutory rights. Also, there's a provision in the Employment Rights Act, section 204 if you're interested, which expressly states that it is immaterial whether the law which governs any person's employment is the law of the United Kingdom or part of the United Kingdom or not. Well, that sounds quite convincing, doesn't it? Well, ultimately all of it failed because the Supreme Court had, in the Duncombe case earlier on, taken into account the existence of an English choice of law clause. In the circumstances, it was argued by the Council that the Supreme Court's decision was not binding. Ultimately, however, the Court were having none of it, and said that both Duncombe and Ravatt cases in the Supreme Court had treated this as a relevant factor, i.e. the existence of the choice of law clause. Accordingly, and despite the ingenious arguments put forward by the Council, the Court of Appeal accordingly came to the view that the English choice of law clause was a relevant factor to take into account. So, since the Employment Tribunal judge had not taken it into account, it meant the case would need to go back to be reconsidered. This hardly seems like a radical outcome. I'm sure if you asked most employers and employees whether it was relevant in deciding that if there was a sufficient link to Britain and British employment law, the parties would have said that if the parties had said that English law should apply to the contract. Most parties would say it's a relevant factor. Well, it does mean, however, now that employers need to be very careful when drafting contracts of employment. Most employers would realise if they put in a jurisdiction clause in the contract, they may well see that as being seen as a relevant factor. However, here we have clear authority indicating a choice of law clause too will be a factor that the court can take into account in deciding whether or not there is a sufficiently close connection with England and Wales. This might well have unintended consequences for an employer. Equally, the advice in the short term has got to be that where an employer is looking at dismissing someone and there's an English choice of law or jurisdiction clause in the contract, it may be necessary for the employer to evaluate objectively whether there is a risk that an unfair dismissal claim or a discrimination claim could be brought in Britain if such a claim does not exist in the country in which the individual works. So that's the case of the British Council and Jeffrey, and why employers with choice of law clauses in their contract need to tread carefully. So there we are. Thank you very much indeed to listening to this particular podcast number 142. It's always a pleasure. Do check out the podcast for David Reed and the special podcast coming out next week on NDAs. By way of a quick thank you, a plug for a film. I went off to the cinema to go see Widows, which has been marketed as a bit of a crime heist. So scene opens with a robbery going wrong, and then successor group comes in and does the robbery. In reality, it's much more than that, much more subtle than that, quite slow, so don't go see it if you're simply in it for the crime heist element, but do go see it. It's a group of 4 women who end up taking over and having to pull the robbery off and how they go about it, but it's also about the relationship between them and surviving men, etc. So, Widows. Give it a go if it's still on at a cinema near you, or Christmas present time come the DVD season. Thank you very much for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.